And here I am looking at Mr. Matthews to liven things up. So I'll start, and folks can just meander their way in, and some of our good directors are over there to give people direction and help you out along the way. And I'm gonna, okay, so we're warning you already, the two stands, to all my speakers, the stands move. The other one shakes and moves. This one just moves. So I'm warning everybody. I have only one arm, as many of you know. This one has been broken, so I am not in a position to catch you, Mr. Mayor, if you decide to move this. So welcome everybody to another Canada Green Space Protection Coalition Town Hall. My name is Barbara Ramsay, and I have the pleasure of chairing the finest group of volunteers that I know in Canada North. Yeah. Many of them are here tonight. We have a lovely room. We want to thank Councillor Curry's staff in her office for assisting us getting a night. This center is very, very busy. And so we were able, on very short notice, to pull the site together for you. It is hard. It's a tough one. How long we wait to talk, and we can't talk soon enough, because in talk comes camaraderie, and out of that comes some peace of mind. So if you don't hear everything you want to hear tonight, I hope you at least feel the warmth of somebody sitting next to you, and remember that you're not alone in this long saga. So welcome, bonjour, Quay. Thank you for coming out to join us this evening. We've got four main goals this evening, and I'm going to just fly right through them. First and foremost is to bring you some important speakers to help you get up to speed and get some thinking going on, and ultimately allowing us to listen to what you have to say. And the second reason is to celebrate the camaraderie, as I said, that comes from being together, even in the face of adversity. And certainly this week, MP Sudds is with us. Adversity comes in the strangest shapes and sizes and messages. And but it should remind us that we are fortunate to live in such a wonderful community, and remind us that we also have a very, very wonderful country, very much grounded in its land and its people. We're grateful for the gift of the unceded territories of the Anishinaabe, lands that we must continue to respect and protect forward, as their generations did before us. Language. How am I doing so far?
Very good.
Excellent. Third, we have a slate of important guests before you tonight, each with their perspectives and portfolios of responsibility. Mm-hmm. The KGPC's goal is always to encourage each of them to leave here and work with us. Help us in some heavy lifting to protect our community and our families, and end this egregious development application once and for all. Fourth, the agenda is a full one. Let's be respectful and short-winded when I let you speak, in order that we are heading home tonight in good time. But last but not least, we are now in the middle of a provincial election. Who knew? Tonight, beyond Karen McCrimmon, our Liberal candidate, Karen is known to everybody, but I'll ask her to stand up quickly in this roll call. We have with us two new candidates as well. I want to introduce Dave Belcher, representing the NDP party. Dave over here in the back. And Scott Phelan, representing the Ontario PC party. thank you for making it out tonight and coming. Appreciate it. So let's get started. For opening remarks, I can think of no person better than our city's leader and convention supporter. You like that? You're sweating. Please welcome Mayor Mark Sutcliffe.
Thank you, Barbara. Bonsoir tout le monde. And first of all, let's hear it for Barbara for the fabulous, fabulous. I think she's put into this for many, many hours. Your leadership has been unbelievable, Barbara. So thank you for everything you do. I want to thank the volunteers as well for everybody who's behind this effort. We are with you, and I'm really glad to see that you have elected officials from every level of government here tonight and candidates in the provincial and federal elections. And I think what you're seeing is how important this is to the community, not just by the turnout, but by the presence of your elected representatives. And look, I know how disappointing this is. I think we would prefer not to be having these town halls and having a different reason to get together in Canada. And I know I speak for Councillor Curry when I say that we're as disappointed as you are how things have played out. But we are resolved to continue fighting. And just because we respect the judicial process doesn't mean we have to agree with the outcomes. And city staff have been reviewing the court's ruling. And Councillor Curry and I were briefed by the city solicitor earlier today. And I can assure you that he has heard our concerns and he has heard your concerns. And I'm very happy to report that as a result, he will be seeking leave to appeal the ruling to the Supreme Court. So that's good news, and I'm glad to see that happening. At the same time, we all know that there are no guarantees with an application to the Supreme Court. We don't know how the court will respond. But for me, I'm glad that the city is doing everything possible. The city is making full use of the tools at our disposal to continue to defend the interests of the residents of Canada North. More than 40 years ago, residents in this community came together to protect something that mattered, something they could all enjoy and share with their neighbors, their families, and their friends. The kind of green space that is the envy of many neighborhoods around the city, the kind of green space that defines this community. So we are going to stand by you. We are going to continue to fight alongside the residents of Canada North to protect this great asset in this wonderful community. Again, I want to thank everybody for your hard work and your conviction. Thank you to all of you who have turned out tonight. I want to thank Jenna Sudds, Member of Parliament and Minister. I want to thank Karen McCrimmon, the MPP, who has been right alongside all of us every step of the way through this. Councillor Curry, of course, who has been leading the way. And by the way, Councillor Curry isn't just a city councillor anymore for the first half of 2025, she's also a deputy mayor. So again, I want to thank the team at the Canada Green Space Protection Coalition. Thank you for your leadership. Thank you for your hard work. Thank you for your dedication to this very important cause. I know that there have been many setbacks, including the most recent, but I know this community. I know how much this matters to you. I know how committed you are to this. We should all be proud of the effort that has gone into defending the rights of Canada North residents, and that is going to continue, and we will continue to work right alongside. Thank you very much.
Well, I guess we can go home now. Thank you very, very much, Mr. Mayor. I think everybody should thank the mayor in the best way that I know how. We'll let him stand up, turn around. There's some green space signs around here. Let's give him a wave of a green space sign. Whoa! That's a wonderful announcement, and we thank you very much for that. And for everybody, just to get a sense, you're going to hear from our legal beagle, Alyssa Tompkins, in a little bit, but it's not easy for large organizations to do the level of consultation with their experts, do the risk assessments, look at this. It's hard enough for our small organization to do the same thing with two good lawyers. It's hard enough for us, but it's a very huge scale and there is so much at risk. So for the city to be able to come here 2 weeks later and make that kind of a statement, for those of you who are awake at night and sending me emails and telling me you can't sleep and you're sick of this fight anymore, these are the small pieces that you should tether yourself to. It's a real difference maker. And the city has a real role. It has a role that it has to exact, and sometimes we wish it would move faster. But I think you have to understand the complexity. And for tonight, I think that's like Santa Claus coming down the chimney. That's just wonderful, wonderful news. And I'm going to tell you why in a little bit. But thank you again, Mr. Mayor. Thank you. Lost in Next. So I feel a little bit like I'm doing WWF tag team here and I'm on the community engagement and representation team. For that, I get to thank you, the crowd. You are all so very, very smart when you cast your vote and elect the quality of representation that we have here in Canada North. And I say that with heartfelt appreciation. I rarely meet someone as fair-minded and hardworking representative as we have at City Hall. She just doesn't quit. She drives me forward constantly. She's our Ward 4 councillor.
Wow, thank you very much, Barbara. Honestly, Barbara, if it weren't for you, I wouldn't have been briefed on this. Barbara sat for 3 hours many years ago and talked, I think, for 3 hours straight. And thank God she did. Thank God she did, because then, there's a lot to understand. So, and Mr. Mayor, thank you so much, first of all, for being here and for being so wonderful to work with. You're not running for election, so there's no need for me to be saying this right now. But what a treat it is to have a mayor like Mark, because, these are complicated issues. And so you have someone who's smart and calm and supportive. And it's been a treat for me, for sure. So thank you so much for this. Okay, so the mayor said we're going to go to the Supreme Court. Wonderful. So my favorite, one of my favorite expressions is, it's a military expression, but, Plan A never survives first contact with the enemy. And, anybody who knows this file knows that you need to have a plan B, C, D, E, right? And so if you were here last year, really it was about a year ago, you heard me talk about some of the other plans, So, we'll go to the Supreme Court. Hopefully they will hear our case this time. That would be ideal, and we will be able to make the case and ensure that the highest court in the land looks at this file, as it should. Because as Sir Terry Matthews tells me, this is about integrity. And the Supreme Court of Canada should be interested in integrity in land deals. So let's hope for that. So on to Plan B. But as I said last time, and I continue to say, whether it's my newsletter or not, the province has powers here. The city has powers here. The federal government has powers here. So, as Barbara's saying, I know some of you are looking out your back door or just looking, at the golf course when you drive by and thinking, oh my gosh, this is so upsetting. And I say, please sleep well at night. There's a lot more to come. And I don't know who's in this audience here, but I will, and I won't give very specific details, but I will just reiterate that the province has a couple of tools that they can use, right? We're in the middle of a provincial election. And I am so appreciative of the candidates. I talked to Scott earlier today, I talked to Karen. I just met the NDP candidate. They are interested, right? There are powers the province has. One of them is a municipal zoning order, which is a power, but it also can be overturned. The other is a provincial interest. And that would end this fight almost immediately. So that is, I think, another thing we need to contemplate. And then the other, obviously, is the city's powers. And I talked about those last year. You know, there's so many ways that the city can look at a file and say, you know what, it's not appropriate. There are easements, and I'll give you that one example because that is very public, that the city has not agreed to disturb, right? The city does not have to allow a developer to rip up its roads and destroy its property. It does not, and it's made that very clear to ClubLink, which is really Morguard. So the city has powers, but if we won at the Supreme Court, that would be ideal. 40% agreement holds, then we're done. If the province invokes the provincial interest, then we're done. And if we get to where the city has to invoke its powers, there are many. The federal government, of course, has the NCC as an option, and the NCC, as I told you, has lands downstream where the water would go. And there is no stormwater management plan, and there continues to be no stormwater management plan. So I'm here to give you some other options and hope, but let's hope for the Supreme Court first and foremost, and know that after that, there are many more, so don't despair. That's all I'll say for now, because I know a lot of other people want to say things, but stay tuned and follow me in my newsletter so that you can keep up to date. But thank you so much again, Mr. Mayor, for bringing us to the Supreme Court.
Thank you. Thanks so much, Cathy, for all you do. And you write a fine newsletter. I know another good newsletter, by the way, too. So. At our last town hall, our next speaker had been elected less than 4 months earlier and was seated in opposition, much to her chagrin, I think, but committed to doing something to help our community with our challenge. Karen McCrimmon crafted a cutting-edge bill for Ontario to address this burgeoning stormwater management issue. Sadly, it never made it out of Queen's Park. I'm going to let you tell her all about that. Please welcome Karen McCrimmon.
You know, one of the most important things we should be is grateful. And my mother's favorite saying was, it's not happiness that makes you grateful. It's gratefulness that makes you happy. And yeah. How lucky are we to live in the blessed country that we live, in the blessed community where we live, with people who care enough to come out on a very cold February night to stand up for each other, to have people like Barbara Ramsay and all of the volunteers and everyone who's worked on this issue. It matters greatly, and I just wanted to say thank you. It touches my heart. I see you all. You never give up, and that's the key. That's absolutely the key. Never give up. We kind of came by Canada and this glorious community. I'm a latecomer, but I count my blessings every day. I count my blessings every day, but I also think because I was blessed, it's my responsibility to protect these blessings and pass them on to the next generation. So, I mean, we have to continue to fight. We have to continue to fight, and don't give up. And thank you, Barbara, about our stormwater management bill. Yes, it would have provided a level of protection for the golf course lands, and it was voted down. But I also had another bill shortly thereafter, and it was about making conversions of commercial real estate to residential real estate easier. It too was voted down. But about a month later, it actually started to show up the changes in the regulations. They wouldn't vote for my bill, but they actually took what was in the bill and implemented it. So I'm not totally You know, I'm not giving up on the stormwater management issue, and I will tell you that our leader, Bonnie Crombie, has committed that if they were to form government, that they would implement that stormwater management act. And that would give us another layer of protection. So we just have to, I don't know what it's going to take to get it indicated, judged to be of provincial interest. So I've done some work, but I still don't have the answer. I'm still not able to find that, what the kind of linchpin that is going to give that to us and to be able to convince whatever government ends up in place. But I know that you would find that fighting for green space is very important. It's very important to me. So, and it's important to my party as well. So I just wanted to say thank you, and just don't give up. Just keep going. We've got your back. Working with Cathy and working with Jenna and working with Barbara and Alyssa and the whole team, they're just such an inspiration. And if we just keep that up and don't give up, we're going to end up being successful. Thank you, everybody.
Thank you, Karen. So our last guest speaker is someone you know well, and our MP Jenna Sudds has well, I'd say certainly seen a wealth of challenges up close this week. A very tough week for our country and its leadership. So we particularly appreciate Jenna making it here today after Parliament downtown. She's been on the ClubLink file since we were, started 6 years ago. And so let's hear what she has to say tonight. We won't keep you too long. I know it's been a long day, but I welcome the Honourable Jenna Sudds, MP and Minister of Families, Children and Social Development.
Good evening, everyone. 6 years. You know, it has been a long road, undoubtedly. And when I look out and see you, we've all been here before. We've been here before. We've fought since day one, and we will continue to fight together. I'm just so thrilled to hear from Mayor Sutcliffe this morning, or just now. I was going to say this morning. It has been a long day, Barbara. I'm just so thrilled. And folks, you know, I think when we see the leadership that we have had at City Hall with both Cathy Curry and our mayor, we are very fortunate that they have taken up the cause and that they are fighting for this day after day. Because frankly, it would be easy for them to do otherwise. It would be easy for them to fight another fight, to appease another community on another issue, but they are there for us. And that is very telling of where their heart is and where it will continue to be. So I'm really, really thrilled to hear the mayor tonight commit to taking this appeal forward. And I think that is tremendous news for all of us. Having said that, I also am really, you know, I'm assured as well that, as Cathy has said, there are other avenues as well. They've been listed already. I won't dwell on them. You know, I still think from my early days when this first came in, I think it was my second week on the job at the time, going door to door, speaking with many of you coming with me, going door to door. You know, we really have an argument to be made when it comes to stormwater management. And if push comes to shove, that is still a very real and viable option for us. So I look forward to being successful in court. Having said that, I'm also reassured, and I hope all of you are, that there are other options out there, that we will not give up, and that we will continue. With that, we've got some, you know, some more important folks to hear from tonight than myself, but I do just want to say before I wrap up, just as well, my sincere thanks to Barbara, to the entire coalition, the volunteers who pour over countless documents, engage in so many complex discussions and meetings. These folks are heroes working on behalf of our community, and I think we should all acknowledge the incredible work that they're doing for us. So with that, folks, let's keep up the fight. We've got this. Thank you.
Thank you, Jenna. Buy Canadian. I was gonna, if I could have got down the basement with then had 2 arms, I would have had a flag or 2 or something on tonight, you know? Yeah, tough week. Thank you. Thank you for just being part of that team and the leadership. The country is very proud. At least my corner. Harley was proud too. I read him the bag of dog treats today, made in Canada. He said, I'll have 3 or 4 of those. So now we're going to drill down on the legal matters of the day. Tonight, I'm bringing you someone that you know well, I think. Our legal expert, Alyssa Tompkins, partner at Gowling WLG, is going to frame and explain in a few minutes the legal landscape. And we are on a bit of a fly here because the mayor has surprised us. I'm just going to be completely bald-faced with you. We had no idea he was going to be able to make that announcement tonight. And I understand why he wanted to do that. And I can't think of a better place to make the announcement than in front of the people it means the most to. So we're going to scramble a little bit, and not because the message changes, it's just the rationale of what we might do and how we might do it next will change. So bear with us. But all to say, Alyssa's going to give you the background on why the Court of Appeal decision is worth appealing for the city and how it might best be done. Not to second guess them, of course, but these are the rationalizations that our group is going through with her in order to give you the information to say, yes, KGPC, that makes good sense to us. That's something we can put some money behind. Because at the end of the day, we can bring you all these great ideas, but if we don't have the money to pay for the service, they won't come to fruition. But before I do that, I also want to say how very fortunate the Canada Green Space Protection Coalition considers itself. And we did not realize how lucky we were when we were introduced to Alyssa Tompkins and her colleague, Charles Dow from David Sobe. But for 6 years, they have literally carried us on their shoulders. They've spoon-fed us the legalese. They've helped us understand the issues that we're not trained in. They've helped give us enough confidence that we can help explain them to you when they can't. It has been a real pleasure to get to know her and also to recognize the diligent and tireless work that she and Charles do on our behalf and selfless work. And I want to make it clear to you because I realize that when we go forward, as we've gone forward in these legal cases, there is a lot of money raised and a lot of money spent. But you need to know that Alyssa and Charles do this selflessly. They do this at discounted rates, much to the chagrin of the firms they're with, I'm sure. but also generously. They attend our fundraising events, they donate, they support it, they support our golf tournaments by buying tables. You don't get this just anywhere. These are people that care. And I'm going to the trouble of saying that tonight because I get that it's easy. As you know, these conversations always end up with me asking for money. I get it. People sit back and say, well, it's lawyers trying to convince you that you need to hire them to take this case. And yes, Barbara, you really need to go to the Supreme Court of Canada. It's more than that. These are legitimate professionals who really care, and we've watched them care and make those personal donations to our cause. So try and sweep that out of your mind and just listen to Alyssa, and she's going to help you understand now why the city of Ottawa is going to the Supreme Court of Canada.
Well, I was going to say something similar to Barbara, that my goal for tonight was to sort of pitch a potential application for leave to the mayor and Councillor Curry, suggesting why this is a good idea. I mean, of course, it's the city has been the party throughout. The city is the party to the contract. We've argued that we're a third-party beneficiary, the community, but the city's the party. So they are always in the best position to be taking the lead on this. And I had said yes. We intervened, as some of you may recall, quite technical here, but we intervened as an added party, not as a so-called friend of the court. So we do have rights. We could have sought leave to appeal to the Supreme Court in our own right. But there's an obvious question there, because the test at the Supreme Court of Canada isn't, are you really, really right? The test to get leave, which is permission for the court to hear your case, is it an issue of public importance? And it's kind of a black box. We know I've been successful on 3 in my career getting leave, so it's doable. You'll hear numbers thrown around at 6%, 7%. It's low, but I'm batting higher than that. It's a bit of a black box though, right? Because it's public importance. So, and they don't give reason on leave decisions. So I speak at conferences and stuff on this kind of thing, and there's ways we do it. There needs to be an interesting issue of law. Ideally, things are uncertain. Well, I'll talk a bit about the Court of Appeals decision, but they kind of acknowledge that there's a really important issue here. They just say, well, we don't need to determine it here because the Court of Appeal didn't tell us, the first panel of the Court of Appeal didn't tell us to. That makes no sense whatsoever. I think I stood before you last time and I said, the first Court of Appeal obviously didn't tell Justice Labrosse to decide this issue in a vacuum without any reference to existing case law. And frankly, I was shocked that the Court of Appeal kind of doubled down on that approach and said, yeah, the Court of Appeal last panel told him to consider these provisions and that's all he had to do. Well, they seem to acknowledge that doing that raises some really interesting legal questions. They just try to dodge why they didn't have to do it there. I think they didn't want to undermine the first panel. I think they didn't want to say the first panel's direction was unclear or anything like that. That's my thought, because after the hearing, I was expecting that this would be a precedent-setting decision. I don't know how many of you watched it, but it was really clear that the judges were struggling with, well, what do we do here? There's this contract. The court struck these 2 provisions on the basis that they were no longer enforceable because of the Perpetuities Act. But they were left with, well, what do we do about it? So the city of Ottawa, and we supported them. Our submissions were all in the alternative. The city made the primary point of, you don't have to do anything. There's case law, and it says when there's a violation of the old common law rule against perpetuities, now codified in the Perpetuities Act,
that's it. Those provisions are struck. And what we said is that that's the right answer. In the alternative, the other legal doctrine that's available to you is severance. We acknowledge that it would be a novel application of severance. But if you didn't want to just leave it the way it was, you could take severance, and if you applied it, you actually get to the same result as the city, which is that the rest of the contract stays intact. Then we offered a further alternative position, which was, look, if the court finds that this operation of the golf course is so arduous for ClubLink and disrupted the balance so much, well, then you can just strike the provisions that apply to the golf course and leave it as open green space. And given that the goal of the court in all of these exercises is to figure out what was the essence of the bargain. The essence of the bargain in this case, as set out in all of the evidence, was green space. And what frustrated me the most in reading the Court of Appeals decision is that's why we said you have to go through one of these established legal doctrines. And part of the reason is one of the things you have to consider is the context of an agreement. And we didn't have that much time, but I tried to take the court through all of the statements that were made at the time. The context, ClubLink's own statements. Under any of these theories, severance, the conduct of the party is one of the things. They were telling you this is going to be green space. And I said there's not one reference in the record to this being about an eventual path to development. And so for Justice Labrosse and now the Court of Appeal to find that that was the essence of the bargain, that doesn't make any sense. I'll also say contracts don't just end. For the Court of Appeal to just say the bargain is at an end, as a matter of law, contracts end. They end on notice, they end on termination. They don't just sort of peter out with time or when circumstances change. So that's another novel legal argument. So even though the court tried to sort of appeal proof itself by saying, well, we don't need to decide this because of what a prior panel of the Court of Appeal, that's something that I think can be dispensed with in the leave application pretty quickly. Like, let's get at these issues. Clearly, the court didn't know what to do. Supreme Court, we need you. So question arises, because yes, tonight we weren't sure what way the city's going to go. We're still going to have to decide. We'd obviously discussed on a preliminary basis. I'll say that disclose privileged information. I had said best case scenario, the city is going to apply for leave. Because like I said, they're the party. The question then arises as to what role we can play. In the past, we've worked with them. We've reviewed their factums. There's another option, which is that we actually seek intervention status in the application for leave to appeal. Kind of confusing, but the mechanism exists in the rules of the Supreme Court of Canada, and that's a possibility for us. It'll really depend on, we'll be discussing with Board Manager Gervais, the City's Council, what arguments they're going to raise. And if there's an argument that might be better made by the coalition, and by, as I've always put it, the people who bought these homes based on ClubLink's representations, then maybe that is an option, but it's not necessary. It's rare. It exists in the rules, but I don't know that it makes a difference on the leave application. It really would depend on if there was a specific point that we thought was better made by our group. And we throughout wanted to move hand in hand with the city, so it's something we'd discuss with them as well. But finding what best role this organization can play with the city is still very much up in question, but we are at arms. Is the point that we've wanted to play some kind of role. As Barbara said, this is, it's an absolute privilege to represent you, but this is not my highest paying file. And I'm actually going back to the Supreme Court this year. Actually, I act for the House of Commons, so back to the Supreme Court next year this year probably a case for them. So we're here because we want to be here. This, aside from the fact that it does give rise to fascinating legal issues, it's a cause that we care about. So we think you have to try, right? That the Court of Appeal didn't give it a fair shot. They dodged. So we still think there's something here. There's something about the fact that, as Sir Terry said, about integrity. And that the Supreme Court, more than the Ontario Court of Appeal, is a justice court. And it's a little bit frustrating at times for me as a lawyer because it makes their jurisprudence less predictable. But this particular panel, this particular bench is very much justice oriented. And that's always been our pitch, that they assumed these obligations. They knew them. They knowingly assumed it. And they, as I said, when you're looking at the context of the contract, they stand in Campo's shoes. They are the developer. And accordingly, the developer's actions in inducing the community to move there, to buy there, to make that choice. I think Barbara wrote a letter to the editor. Said, this isn't about NIMBYism. This is about people making a choice, making a decision based on statements. And yeah, technically it's true. There was always this path to development. We've never denied that. It's why we couldn't raise some of the arguments we wanted to raise. Like, I think way back I had floated the idea of a charitable purpose trust, but ultimately there was this very, very narrow path to development. However, that was always protected. That path always went through the city. And that always gave the community powerful protection. It was going to have to go through the city, and somebody like Councillor Curry would be standing before you having to explain why they were not going to take a conveyance of the golf course lands for $1. So that gave you a lot of power because, boy, I wouldn't envy that particular councillor trying to explain it to a room like this. So that gave the community a lot of power. So that's why that we say that was a really important protection. But it's consistent with the overall focus of the agreement. So in terms of, I have on my screen a play-by-play of the Court of Appeals decision. Ultimately, I don't know that it's actually helpful for me to walk you through it. It's very technical, but ultimately they dodge the main arguments. They don't really grapple with our arguments. They grapple with the windfall argument, and they kind of say, oh, you got the benefit of it since 1987, like, therefore you should be happy. I mean, that, I don't know where on earth that conclusion came from. There was some other odd statements that it is reasonable to infer that the purchase price ClubLink paid included the possibility of redeveloping the land. I had actually created a flowchart for the court showing how minuscule that possibility was. Again, because it had to pass through the city. The notion that that 0.01% chance of redevelopment had anything to do with the purchase price is absurd. I don't believe that that's a quote unquote reasonable inference. But that's the kind of argument we make if we get leave to the Supreme Court. Just so you understand, again, the leave process to the Supreme Court is about raising interesting questions. So if you end up seeing the leave materials from the city, at the leave stage, you're more saying, the Court of Appeals found this. It raises these interesting questions compared to case law in other provinces, even in other jurisdictions, to go back to the UK or even the United States. But you'll find that it's not, you're trying to convince the court that it's not an exercise in what we call error correction. So just so you understand, if you see the city's materials and you're wondering, why are they not saying the Court of Appeals completely out to lunch? They may, but they may also frame it in a more, this raises really interesting issues. They will explain that it was wrong of the Court of Appeal to dodge that, but it's very much the question you're answering isn't did the Court of Appeal err, but rather does the case raise an issue of public importance. So that's just a final comment that I wanted to share in the events that you review the city's leaf materials. Otherwise, is this the point for questions or is it later? Okay, I'm happy to take questions on the Court of Appeal decision, but it's very simple. Yes.
In Canada, do we actually sign agreements and live with them with integrity? Isn't it as simple as that? There was an agreement. Do we really want a country that does not uphold agreements?
I mean, the answer is, it gets complicated when courts strike pieces. But what the court is trying to figure out, as I said, is what is the essence of the bargain? And that's what we say. Yes, the court needs to uphold the essence of the bargain because ClubLink knowingly assumed that quid pro quo, that they would be allowed their development in exchange for green space, and they should be held. Yes.
Donald Trump, what would he do?
Donald Trump. So, questions came from Mr. Terry Matthews, who, before he jumped up, I was going to suggest, if you would be so kind, we have a mic, we did have a microphone. We've got Neil with a microphone. We're glad to come to you. You can jump up at this podium back here. Please state your name and your connection to the green space. You don't need to give me your living address, but if you want to tell me where you live, I don't mind either. And the reason I want to do that is because we have people in the room here tonight, and you know, it's a free country, and that's where we are. But we know for a fact we've got our opposition in the room tonight. The developers are here. They're always here. They're always around. So you can get up and ask a question, or you can get up and tell us you changed your mind. But for now, again, just to keep us on track and get you home early, keep the questions short. And if at this point you could ask questions germane to the legalities behind the issues. So if you've got a question about the law, ask Alyssa. If your question is beyond that, leave it. There's going to be another question and answer period after I try to bring you up to speed on what the coalition is thinking, okay? And with that, well, and here's another person whose name doesn't really need to be stated. Marianne Wilkinson is at the microphone. Yes, always. And go ahead, Marianne.
Yeah, I just was kind of curious about this because I was the only person from Canada in the negotiation of this agreement. Because there was a problem with our council thought we didn't need one. And I kind of think sometimes I wish we didn't have one because it's been a pain. But anyway, the question is about the two laws that were taken out. They seem to think it meant they had a right to develop. Actually, that was put in as a penalty for the city. Developer said, if we do give it to the city, how do we make sure the city doesn't turn around and develop it? And that was put in to say that happens and it's not city going to develop, it's going to be a developer. We figured out the community would never let that happen. So it was actually, and I think you did talk that way a little bit about the deterrent a little bit, but it seems to me that I kept hearing that this right to develop, and I can figure out, we never put in a right to develop in that agreement. I was there as part of it. And so I was pretty concerned that that people can reinterpret things, which I guess happens all the time in the law, but they don't bother to look at what's right behind it. Is that kind of thing going to be going on when it goes to the Supreme Court? So that, because I think there isn't, since Terry says the integrity is definitely there, and I really agree with you about that being important, but is it also important to try to say that somewhere along the line that's not what the agreement is about, because there's very direct one clause in there that says specifically this is for all the area is to be green space. And you might be aware, not all that land has been deeded over yet. We have green space yet to be deeded, but it lives out on it in the development that's happening north on the other side of the Beaver Pond.
what I'll say again is that's why
Yeah.
that's why we said the Court of Appeal committed the same error as Justice Labros. They failed to take into account the context. As I said, ClubLink was unable, and I even had Charles, who couldn't be here tonight, I had him go through the record before the Court of Appeal hearing because I wanted to tell the court there was not one piece of evidence, one page, one line about a path to redevelopment. That is a finding made without evidence. And the Court of Appeal didn't even grapple or acknowledge that argument in their reasons. But there was nothing in the context, in the quote unquote factual matrix, to use legalese. So I think that's absolutely relevant because if it was an essential term, we're not allowed to, in the law, we're not allowed to ask a party, one party's intention or understanding of a contract is not relevant. It has to be objective, shared. That's why we're looking in the record as a whole for documents that were shared by both parties. So right now, they're basically saying ClubLink's intent was to develop it. There's nothing in the evidence, no reasonable inference. So I think I'm just putting it in the legal constraints that we can't have an affidavit from Marianne saying this is what we intended. That would be struck out by the court. But we can look to the whole context where there's nothing.
Yeah, well, let me just, okay, seems to be a lot better standing here. If you want to still-
I think you just need one or the other off. On and on.
Alyssa, Guy Summers, a longtime Canada Club member and resident. My heart's still in Canada. So, quick question, real quick. The city's appeal or leave, request for leave, is it countered by ClubLink or is it simply a request to the Supreme Court?
ClubLink does get a right to respond. So what happens is the city has, I think, 20 pages, and then ClubLink gets to respond, and then there's a 5-page reply the city will get. And as I said, in there, the rules technically provide that we could intervene as an actual participant in that process, but we may choose to be more effective sort of behind the scenes working with to be determined.
Hi, I have a question about your name and what brings you?
Yeah. Hi, my name is Tao, and I'm living in Canada Lakes. So I have a question about our legal options. Right? I know so far we have been using our intervener status, working with the city, but I'm wondering, after all this, if we couldn't get into the appeal court, Supreme Court, are we having other legal options afterward? I mean, we could thinking ourselves as independent parties and then explore all our legal options. Are we having any plan on that, or what was your thinking on that?
Shut that off. Thank you.
So thus far, we've been focused on this particular fight. There are substantial resources, but they're still limited. So we're focusing on the fight we have in front of us. We fought at the OLT as an intervener as well. That was a significant financial endeavor as well. This one, we're still focused on this argument. We still believe we can win this one. Obviously, some risk. I can't stand beside you and say I guarantee we're going to win, but I think we definitely still have a chance and we should pursue it. And then after that, if that doesn't work, yes, along with all of the other options, all of the other protections that exist, we would then consider legal options on behalf of the residents, on behalf of the community more directly. But it's not obvious because you're not party to like the agreements you have. Would you be suing all of them? We're trying to come up with ideas, but like I said, it's not something we've been able to devote sufficient time and resources. Did you want to add anything?
No, other than to just remind you, and I know it's hard looking at this from the outside, because it's hard for the coalition too. You want to run forward, and sometimes you just cannot run. You have to walk, and you have to remember that, as Alyssa says, when you're not a party to that original agreement, of course, we all know why it was crafted. It was crafted for the benefit of the community and to ensure a sustainable community was built here. But the reality of it is, we can't run faster than the process itself. And so that's why we have to hurry up and wait. And tonight, while we had some wonderful news from the mayor, and it is wonderful news, and I try to maintain my objectivity, so I'm trying not to grin from ear to ear. It's wonderful news. But unfortunately, it's going to cause us to have to be patient again. Why? Because all of the levels of government that we work with are going to tell us. What are they going to tell us? It's before the courts, Barbara. And that is what Karen was alluding to earlier. And we're in the middle of a provincial election, and whoever you elect to represent you at Queen's Park, that's what they're going to continue to tell us. And Jenna Sudds hits similar walls at the federal level because they all have interests, but they cannot bring their interests to bear, they believe, while it's in front of the courts. So while we're very happy, well, if you ask me what we really wanted, yes, we really wanted to hear the city is going to pursue this to the Supreme Court. And Alyssa's given you a taste of why. And obviously, I mean, she's not the only one that feels this way, right? Obviously, the city's experts, their legal experts, their lawyers that serve at the city, they've come to the same conclusion. And they're the ones that are going to have to pay for this. So just be patient. Recognize that this is good news, but I'm going to be back in front of you telling you I can't run forward. I can't do these other things. And I can't do them because it takes money to do it all. And we have to be very rational. I will have some good news about money in a little bit, but we always, this is expensive. This is important work. And we have to be as important in our organization so that we leverage every damn dollar that we've got to get $2 worth out of it. And we've been very good at it. We've been very good at it. And once again, one of the reasons is because we've been lucky enough to find people like Alyssa Tompkins that really care about community and bring the very best to bear. And so that's why I'm not standing, you're not hearing my knees shake. Because if I'm going to Supreme Court, I'm going with her. She's 3 for 3. I'm gone. And the city knows it too. She works for the city from time to time. So the advice we're getting, again, we're in good hands here. And we're going to continue to, I think, the board is very, very comfortable continuing to approach this file in a very, very logical way. And while some of you wish we were running sometimes, we're only walking. I know that, but there's a reason. There's a reason for it. Thank you, Alyssa. So, yeah. Be patient with me because I'm going to have to, that was 2023. Remember all those? Mm-hmm. Still all the same number of people here. Like 6 years in. Oh, Canada. Wow. So what's up next for the KGPC? So I'm just going to take a pencil here. No. This, what we were thinking coming into tonight, with our fingers crossed behind our back, that the mayor and our good councillor would be able to talk to a process they were developing at the city. Little did we expect they were going to be able to come here and say the decision's been made, we're going forward. our first legal option, if we're going forward, and I'm not gonna repeat what's been said. The city, the ideal position, the ideal thought in the minds of our lawyers was the city would appeal to the Supreme Court for the reasons that Alyssa has already stated. They have they're in the position to make the best argument. It's less risky than us pursuing it as an intervener. Just to confirm the timeline that hasn't been talked about on this run to the Supreme Court, the application for leave, so let me remind you, it's a two-step process. The first step is the application for leave to appeal. It's a step, a process. There is a 60-day deadline from the Court of Appeal decision, which means the deadline is essentially March 21st. In legalese, that may be March 20, and I don't know what's one or the other. The city now in its pursuit will have to file its application by that date. If we were going to the Supreme Court, we too would have to file our application for leave by that date. It usually takes about 6 months for that leave to be assessed by a subpanel of the court, and it either gets a thumbs up to the court or a thumbs down. If you get a thumbs down, you're done. Process is over. And that's what happened the last time, if you'll recall, when the city took it to the Supreme Court. Now, it didn't happen quickly. And so for those of you, we've had a couple conversations online, et cetera, people asking, wow, we lost before, why would we even go again? Well, the issue, and from the perspective of, again, the lawyers, this isn't the pharmacist standing up here telling you this, the lawyers, the reality of it is, it got very good consideration. The court did not decide against the city's application quickly. It took it out for discussion and consideration. And there was some disagreement both ways. So at the end of the day, they decided not to hear the matter. But it wasn't thrown out like 5 minutes after it arrived. And that leads you to believe that while we're in a different place and they're putting a different decision in front of the court, nonetheless, the issue is a broad one. And that's what gives experts like Alyssa confidence that there is something here that's arguable. So we could sit here and say, and clap and applaud and thank the city for taking this up and listening to us and its residents. But we think there's a potential win here too. So that would take about 6 months. Thumbs down, it's over. That is the end of the legal options as we know them on a 40% agreement. 40% agreement then is dead. And in all essence, at that point, well, it's back in front of ClubLink. Are they making a development application or what exactly are they doing? And then, of course, it rolls forward to these other issues we've been talking about, stormwater, contamination, all these other issues, they come into play then. Other governments come into play then in a big way. And that's why I said a bit ago, that's part of me says, oh no, another court, because again, everybody has an opportunity to sit back and do nothing. And I don't like people sitting back and doing nothing. The decision of the court, I'm told, could take up to a year. So if you're looking at a timeline, March 21st, add 6 months to get the application, you're into the end of the summer, early fall, and the hearing, 6 to 9 months. If you got the thumbs up, the hearing at the court is a 6 to 9 month wait. It's not so bad. But then a decision from the court could take up to a year. So we're well into 2026 if that's the case. I should advance my slide. I did advance my slide. Next option. Let's just talk about the funding at the SCC. Take a breath before you look at those numbers. Everybody sitting down? You should sit down. So again, if we were pursuing this, if the coalition was pursuing this, we're looking for step one, the application for leave. We would anticipate needing about $30,000 to cover. The good news is the coalition has 30,000. So yes, and we thank you for that. We do have that money, and in anticipation of coming out here, and again, not knowing that we had the city with a decision in hand, we were trying to put our cards on the table and give you something to think about, okay? So the board and the 12 volunteers around the board have exercised good fiduciary responsibility and rationalized that if this is what the community wants, then we would take $30,000 and hire our team, and away we would go and pursue. We don't need to do that necessarily. Step 2, there's no point in doing step 1 if you can't climb step 2. So what would be the point of pursuing the leave application if we didn't have the $130,000 it's going to take to go to the Supreme Court? So we were in a bit of a quandary coming here. And what we were going to tell you is, well, we have 30, we don't have 130. So guess what, guys? We're raising money again, if that's what the community wants to do. And so we stand here, I stand here with the board and the coalition to say, our role is not to decide for you. We're not elected by you. We're simply here as a group of people to give you one voice and to leverage your $10 against 2,000 other $10 contributions. That's always our goal. So we were coming here to say, we're going to put this in front of you. We're going to get more information in the coming weeks. But if you want to seriously think about the Supreme Court of Canada, we've got to come up with 130,000. Now, some of you may go, and some of you who are new to this file will say, well, that's ridiculous, I might as well pack up. We don't need to do that, because we already did that once. We did that 15 months ago. Do you not recall? We were in this very room. And I said, if you want us to act, you have to give us the money to act. And what did you do? You sent us $135,000 in 2 weeks. Yeah. Some people were able to do more. The point being, we're here because we wanted to put the option on the table. I don't want to belabor the option because honestly, I don't have to. Now that the city has made this decision. So you can see how important this decision is for the city. And you've heard the legal expertise that tells you it's actually the best. And it's a really nice decision because we don't have to raise $130,000. Next. The city succeeds in its leave application, and the Canada Green Space Protection Coalition applies for party status if it seems worthwhile. So this is yet another option that could happen. So again, remember, they've got to get through step 1. They've got to get a thumbs up. And then there is the opportunity through our council to seek party status and present at the court. It's obviously going to be less expensive than developing and fielding an entire application ourselves. The difficult part of it is you're going to pay several tens of thousands of dollars, bill yet to be determined, for about 10 minutes a time. So if there's a great argument that comes forward, that is, as Alyssa said, the city's team deems somebody else is better to present, or we feel is an oversight, but there's an option for us there, that is still in the cards. It's way too soon to know what that would be, but it's still an option. But it certainly would be a less expensive option. So again, when we were coming here tonight, how do we keep all of our options open? And that's always our goal. And I know it frustrates some of you, but we don't take decisions we don't have to take. We wait and let the play come to us. We had a strategy, and I'm just sharing this because I just like to be transparent. So the coalition rationalized that if we had to raise this money, and we would have to do it quickly, because if you're following us, March 21st is the deadline for the leave application. It would have to be filed by that date. So yes, the coalition has the money to pay the lawyers to write and prepare and develop the leave application. But there would be no point in doing that if we didn't have, we know we had the funds to go the distance if we won. So we were going to have to set an arbitrary deadline like February 28th in order to raise the $130,000 so that we could stand in front of you like responsible, reasonable people and say, we can do this if we win. I want to just take a moment to say to you and remind you that this is but a group of volunteers. And they're smart people. There's a lot of smart people in this community, and I know you know that. But these are smart people. And they had to sit there and rationalize a way that would allow and give you folks the opportunity to listen to the material, say yay or nay, thumbs up, thumbs down, I'm in. I'm going to give you $5,000 to contribute to this because I just really want to give this 40% agreement one last hurrah. That's what we're going to do. Our rationalization was, but what if we don't get the leave application? So you've given us all this money and we don't get the leave application, what are we going to do? We actually even have already rationalized the plan to refund your money to you. So yeah, it's kind of a crazy organization, I think, but nonetheless, we're standing in front of you as volunteers. We're going to take your money and we're going to do everything we can possibly do with it, or we were going to give you your money back if we don't need it. So that's how much time we spent in 2 weeks developing this concept for you. And the city blew it all out of the water by agreeing. So, we still value money. We still have places we can go with money. And one of the places we can go with money, and one of the things you folks talk with us about a lot is, why don't you do more campaigning? Why don't you talk about contamination? Why don't you engage the community? People will listen. You're absolutely right. All of our communications have been done on the backs of volunteers, some of them professional, but nonetheless, we do things in the most economical manner that we can. We've often thought that maybe it's time just to spend some money and buy some really strong advertising campaigns to help dissolve this NIMBYism that we hear. You folks, just a bunch of wealthy people living on a golf course. They don't want to lose their golf course. I've never had anybody call me up or in all the emails I get tell me, this is really only about golf for me, Barbara. I don't want to hear anything else. I've never had anybody tell me that, but people think that's our problem. So there is a thread in the mind of some people that this is something we should be investing in. And this is something we could be investing in while we're waiting for another year plus for the courts to play out. And so that is something we could do. The political aspect, well, this is, whether you like it or not, this is a political fight. It really, really is. It's always political. And this is a 2-election year. I mean, it's kind of like having, 2 February 29th. We've got a provincial election now, and we're going to have a federal election at some time between now and October. So for those that know me, vote. Think about who you're voting for. ask the candidates what they're gonna do for you on this issue. And you're gonna hear all kinds of things, and some of them, you know, the reality of it is they're one person in a party. And it's even tougher if you're one person in a party that's not winning and governing. It's very, very tough. But nonetheless, there are ways that they can bring their expertise to help us. And I can say up until now, we've had wonderful elected representatives, and I thank you every day for giving me this class act in the front row. I'm telling you, like if volunteer, but they do answer the calls. They do come out. You know, I never not had a call return ever. So it's wonderful. And part of the reason that is, and I'm going to use this opportunity before I turn it back to you for questions and answers. One of the reasons is many of you say sometimes I'm just too nice. That I really wish you would just tell them, and you should just take the microphone and just give them a blast. And for those that know me well, I am kind of capable of doing that. But it's not going to get us anywhere. On an issue as complex and as deep as this, you do better with friends. You do better with friends. Donald Trump has not realized that yet in his advance. And somehow he's going to learn the question, and whether he learns it in English and French in Canada or in Spanish in Mexico, he's going to get an answer. You don't win people over doing it. And while I don't always agree, and I think our board and some of our decisions, we push hard. You know, we push hard on Councillor Curry. We push hard on Karen McCrimmon. We do, but we do it respectfully, and we do it with a shared system of value that we know we're all working for the community, and we're trying to do our best bit. So if you think I'm not working fast enough or hard enough, phone me up and tell me. I'll gladly explain what it is I'm trying to accomplish and why I can't. But we do get a lot of questions on the legal side. Why don't we just sue the city? Why don't we just sue ClubLink? And we just can't do that. And one of the reasons we can't do it is, number one, we haven't suffered any damages yet. I mean, my gray hair doesn't count. But you can't just do that. There's a process, and you have to go through. So, all to say, cross out the $130,000 because I don't need to hit you up for that. Right? But what I do want to hit you up for are more questions and answers and comments about what you've heard. What do you think? Do you feel good about another 12 to 15 months of legal waiting? Do you feel good about that? Yeah. Yeah? That recorded for the mayor. I'm happy to take questions and answers, but I'm also happy to send you home if you want to go. I see some hands here. We are always looking for donations, and I just want to take, because I've got the microphone. You ask from time to time why the coalition isn't more transparent about our financial situation. And I'm going to be just really honest with you. The same reason that there's developers sitting in the room tonight. The developers are on our 2,000 plus supporter list. They get all the information that you do. They know enough, you know? They know enough about what we do. We accept that we can't do it behind a brick wall, that, you know, some of the information gets out. But I'm going to stand in front of you tonight and say, we worked really, really hard with the money that you gave us last year at the court to fight at the Court of Appeal. I'm just going to be completely transparent. Right now, we have over $50,000 in our coffers still. So That's why the board is in a position to decide to say to you, if you want to spend $30,000 and go to the Court of Appeal, KGPC, we can do that for you. We've got that money. The money is not for us to decide what to do. It's for you to tell us how you want that money spent because it was your money. Okay? So along the way, when we can't fund something, you know what I'm going to say in the e-news. I'm going to talk about the weather, I'm going to talk about Harley, then we're going to talk about the issue, and then I'm going to ask you for more money. I'm pretty predictable. But that is kind of where we are now. So we're not moribund. We've got funds. So when we think about a public awareness campaign, is that maybe a good investment of some of that money? Think about that. Think about it. And the next thing I'm going to tell you is that when you leave, Jen and some of our other directors out here, we've created a little an email on our board, are looking for feedback from you. Send me your ideas. Send our ideas. We're going to juggle them all around. We're going to apply some AI to it, let it do the work. We'll juggle the ideas around and we'll come out of that with a plan. But we're not going to race out and do it because I'm going to come to you first. It's hard to get together in person. We might do it by a virtual online because that works. And we're all getting better and better about our virtual skills. So we can easily do that. But getting our options in order is our next big step. Over the next couple of weeks, we're gonna wait to see what the city comes up with, what the application is it makes. Our relationship has always been a positive one, and again, I thank Cathy Curry, Councillor Curry, and the mayor for ensuring that we're in the loop. And we try to be respectful. It's not our place to tell the city what to do. They're going to decide what they do because they're responsible to all the taxpayers. But nonetheless, we're going to be there, and they respect our legal counsel. So we do invest dollars in making sure our legal counsel is available to the city if it wants a second opinion. So when that happens, you're going to hear from us what we think, what we're hearing, and what possible roles are for us. But if we leave here tonight, what you can walk away, thank the mayor once again, wherever he's gone, and the good councillor in front of us. We've got money. We can take a reasonable next step. We're not in a place we were November 2023, where it was a turn the switch on or off. If you want us to participate, we need $100,000. We're not there. We can sit where we are, we can think, we can watch, we can make a decision that works for you. Thank you. Am I on? That's just my loud voice.
No, it's on. It's still on.
It's got a red line.
Okay.
Yes, sir.
My name is Tony D. Marinas. I'm a Beaverbrook resident. I'm also a member of the golf club. As a golfer, hi. I've been in Beaverbrook for a long time. Actually, I kind of got stuck here in 1977 and met someone here. She hasn't let me leave, so that's a good thing. So something, and again, it's not a question, it's just a comment, and it's something that tweaked into my head when Marianne was speaking. When I joined Canada Golf Club, it was owned by Genstar at the time. And then Genstar then sold it to ClubLink Corporation. And ClubLink Corporation at the time was Bruce Simmons, and his goals, based on what was explained to us at the time, was that they wanted to have a range of golf clubs we could all play through the province of Ontario, and maybe into Quebec at some point. Not that they want to develop it since has been taken over by another group of individuals, or one major individual, Mark Sutcliffe, and his goals obviously are to develop properties. And I'm wondering if, again, it's not a question, it's a comment, are we fighting the wrong ClubLink? The ClubLink that bought the property
Gemstar is a company that was developed in golf, and not a company that's now developing and demolishing golf clubs and green space.
I really need this. I've got the lungs of. I think you're right, Tony. I mean, the ClubLink of today is not the ClubLink of yesterday, but it is a business structure, and it's owned by Morguard, and the decisions are made by Morguard for ClubLink, or they have some reporting mechanism. I don't know that it changes anything from our perspective. They operate as ClubLink. That is their operating structure. The reality of it is there's two other developers, Minto and Richcraft, that have saddled up with them. So, I mean, if you're going hunting for bunnies, make sure you hit them all. That'd be my recommendation, but I'm just a pharmacist. It's I don't think we can change anything. And it, again, to the comment that I get frequently, and Alyssa continues to assure me, we just can't go out suing organizations because they're doing things we don't like. I mean, it doesn't seem right that thousands of people should be so frustrated, so stressed for such a long period of time. I mean, let's face it, my business is healthcare. This is healthcare changing material here when people live under this kind of stress for long periods of time. And I hear from people in this room that worry about losing their houses, not being able to take the right decision about their homes. That's not a good place to be. But it's not evident to me, and I have a lot of confidence in the lady to my left. If there was an easy and low cherry there, we'd have been on that by now. Mr. Terry Matthews, sir.
I think everybody should know that this is the biggest Canada. It's the biggest tech park in Canada. Like 30-odd thousand employees, 500 odd tech companies, many people. It's a little bit like a magnet. It attracts people because of the environment that we have here, this side of Ottawa. Whether it's the green space or whether it's actually, the green space around Canada itself. This is a magnet. Now, I happen to be very involved in the tech sector, and the areas in tech are about to take off big time. I don't want to see that screwed up. And if you take a look at just the developers that put houses and big apartments up, they're lucky because it is a magnet for tech. And that magnet is a lot to do with the green space. I don't want to see that screwed up. Certainly from my perspective, involved every day in tech, it's about to take off. Don't screw it up. Now, the people I see in this room, I notice many people that I've worked with in the past or I recognize in the tech sector. A lot of tech sector people live in this area. And they've had enough of this change the golf course into some tightly organized homes and so on. It's not good. Don't wreck the environment. It is a magnet. I think we should all be very active in finding ways to support Canada Green Space Protection Coalition. I'm certainly going to be there. Thank you.
Thanks, Terry. Yeah, I mean, I really, it goes without saying that when you raise this idea, when you listen to people talk about, give this more air, give it more publicity. I know our political friends don't always want to hear that. because it makes life harder, right? Sometimes when people are talking about things, it makes it harder to make things happen. Some good things happen in vacuums. But I'll be honest with you. I have a greater concern about making sure people are aware what the downside of failure on this development is. And I agree with you, Terry. The upside is fantastic, and we should not lose it. We should not lose the green space and the open space. We shouldn't lose it. But we shouldn't lose it because it's an essential part of stormwater management in Canada Lakes. I mean, it's a public safety issue. And so too is the mercury that ClubLink bought when it bought the golf course. That's ClubLink's mercury now. And it's in the ground and it's sitting there quietly. And as long as we leave it, it's like the asbestos in my grandmother's house. If you don't touch it, bad things won't happen to you. But when you go around clawing, breaking, blasting, detreeing, grading to bare rock, where is the plan? Where is the management around that? We haven't seen or heard that yet. The analysis is bare bones, phase 1 and phase 2 environmental assessment. We need more. We need more protection from that. So how do we get that? How do we get that? And to do that, again, I turn back to the front row and our speakers tonight. These are very talented people. They're wonderful resources. They're wonderful tools to listen, and they're on the same page as we are. So I'm still thinking about that. And again, so I say to you, think about that. What do you think about that? Is that something we should be doing? And if you think it is, leave with one of our little chits, but I can give you the address. It's feedback at our.canadagreenspace.ca, but you also know where I live. So just come up. Somebody come up to the door. You know, they've survived Harley, Terry. People come up and Harley's.
Maybe Harley should be attacking the leader of ClubLink.
Maybe I should stop feeding him so much and let those 6-hole golfers, instead of having them steal the balls on the 6th green from the golfers out there. So yeah, think about that. And if you go home and you've got an idea, you think we haven't talked about it yet, send it to me. We're happy. We want to hear from you. We work for you. So we're not here telling you what you need to do. I want you to tell me what you want to do. Who's next? Go ahead. And name, please, so I know who I'm talking to here.
My name is Sylvia. My name is Sylvia Ralph Thibodeau, and I'm a resident of Canada Lakes, and I love the golf course. I have a very quick question directed to council, and I want a very short, simple answer because we're all getting tired. But my understanding is that the most recent court decision has an impact on other agreements between developers and municipalities, perhaps even across the province. Is that true?
Well, we're still analyzing that. I think the Court of Appeal tried to limit its findings to this agreement. I don't think that they succeeded. So to the extent that it raises these issues about what happens to the rest of contracts when certain provisions get struck, absolutely. It goes beyond those agreements between municipalities. It potentially impacts all contracts. And that's what we're going to be saying to the Supreme Court, which is why it's important. But yeah, the impact is much broader than this, notwithstanding the Court of Appeal's attempt to narrow it and accordingly dodge the issue.
Yeah, Sylvia, and just the second part of that is that's why it makes the most sense that the city pursue the Supreme Court. Cathy.
I just want to make one comment on that. just, as I was just interviewed by the media there, I wanted to make sure I said this, I didn't say it earlier. But, at the end of the day, the decision to go to the Supreme Court of Canada actually rested with our city solicitor, right? And I think you have to ask the question, why would a city solicitor, if you are even thinking this, want to protect golfers? The city solicitor doesn't care about golf. Really, the city solicitor doesn't care about much other than this agreement and what this case means. So as I think you've heard today, the mayor is given permission to announce that, but it was the city solicitor that looked at the legal argument here and determined that this is a case that the Supreme Court needs to hear. So I want to make that clear to everyone. The city solicitor is not political. The city solicitor is looking at this agreement and saying, as Alyssa was just saying, this has ramifications much more broadly. When you see somebody acting in this way, there's an agreement. We don't care about the agreement. Let's see if we can weasel our way out of this because of one phrase or one little semicolon or something like that. That's something that needs to be looked at, right? And so I'm so thrilled that this is the case today, but I want you to realize that the city solicitor doesn't lightly decide to take this case to the Supreme Court. And that we went last time, and it was David White, our other city solicitor, who made that decision within a millisecond. This time it took almost 2 full weeks for our city legal team to look at the actual ruling and see the impact of this. So I just wanted to make sure you understand that this is not just about, and I've said this to the 3 emails I think I've gotten where people have said, oh, Cathy, you're going to support rich white golfers. I actually get emails like that, if you can believe it or not. And I have to say, actually not. Thank you for sending me your feedback, but that is not it at all. So I hope you understand the importance of this case.
Hi, my name is Amy. We live on Nipson Drive. I have 2 children who had Earl of March. Since we bought our house almost 5 years ago, the thing that's stuck in my mind is that if this is developed, and there are 1,500 houses, half of them have children. Most people have 2 children. That's 1,500 children who need to find schools in our neighborhood. I don't expect anyone to have an answer, but I really feel like I've heard nothing about that. And as my kids are out of school with more children in portables than in classrooms, I feel like this deserves more consideration.
So, Amy, it's nice to meet you, and welcome to the neighborhood. And 5 years is 1 year less than 6 years. And we were doing the difficulties, the inequities in this development and its characteristics 6 years ago in front of the city. We're all very well aware. There's a shortage of school space now that will be terribly worsened. We also dealt with all the transportation issues back then. So all this is on the table. It's kind of off to the side while we pursue all the 40% agreement till its end. So it will either prevail or it will end, one or the other. But we're very well aware of that. It's all well documented in the city application. And just to wrap that up, I'll say something I'm sure as a mom you don't want to hear. But the reality of it is these development applications do not have to consider education in schools and accessibility, and that it's just not part of these development applications. And it's ridiculous. And very, very frustrating, very, very frustrating. And so it is yet an important reason just why this should not happen.
I was at the most recent Earl of March council meeting just a couple weeks ago. As we all know, Earl of March is insanely overcrowded. It is now the biggest school in the city, and they are putting an expansion on it thanks to the French government. But that is not going to get rid of all of the portables. As we know what goes on around here. Same thing with our elementary schools in the neighborhood. They're all very, very full. So
Popular place to live.
Yeah. So, any more questions? We're still. I mean, we can all go home, but if there's another question in the room, or are we good? So I see a gentleman with his hand up over there.
Ivan Blake. I live on Goodson Drive.
Hi, Ivan.
This is our 35th year at Canada Lake.
Congratulations.
Is there not a poison pill in this, buried in this potential agreement, potential development? I'm just curious, and perhaps the councillor could answer. If, well down the road, if we were unsuccessful at every level, and the development did proceed, and there are 700 homes on the golf course, each of which, according to the real estate agent that spoke to us some years ago, each of which lost $100,000 in value. And we've all suffered 7 years, 8 years, 9 years worth of worry over all of this, to the tune of $50,000 per household for worry. Do we not have a class action suit worth some $100 million, which we could then launch against ClubLink, Morguard, Richcraft, and Minto? And $100 million would only take care of the houses on the golf course. Another 700-800 homes in the area could equally be party to that class action suit. ClubLink signed on to their obligations under the 40% agreement some 40 years ago. Would they not be liable under a class action suit for $100 million worth of damages?
I'll let you answer this, but I'll open it up for her. A class action lawsuit could only occur once you've suffered damages. So we're a long way from having suffered damages. Unfortunately, as I said, my gray hair doesn't count as one.
Isn't this a poison pill? The possibility of wouldn't this make the entire enterprise catastrophic investment by the developer? In fact, Morguard is already on the ropes financially. This would really, the prospect of a loss in the future, to make the entire enterprise.
So I actually do plaintiff side class action work on the side. Like I said, this file isn't my real job. Along with contract and shareholder disputes for all your tax, I am leading a plaintiff side class action in the territory of Yukon. Obviously, if there was something there, we'd look into it. The hard part is, what is the cause of action? And it's not so clear. As I said, there was a representation, but in the contract, there was always this path to development. So had you gone to a lawyer at the time, a lawyer would have reviewed it and said, probably, there's this clause and it might give rise to a perpetuities problem. So all to say, it's not a slam dunk. All of these causes of action require, as Barbara said, damages. There's often a question of reasonable reliance. But all to say, like Barbara referred to the fact that I keep saying to her, you can't just go around suing people because you don't like what they're doing. And it's true, because what we have to do is find a cause of action. So you've heard of some of them. Negligence is a cause of action. Battery is a cause of action. Breach of contract is a cause of action. So we have to actually take a cause of action, find a legal test, and find what it applies to. I have a few in mind. I've certainly not given up on that possibility. As I said earlier, it's not something we've spent a lot of time exploring. It's not going to be something obvious. So it's not an obvious poison pill. Otherwise, ClubLink wouldn't be doing this. They have great lawyers on their side. There's no doubt. They hired one of the most expensive firms on Bay Street. We're up to the task in taking them on. I'm not worried about that. It's more, but it is the case that if there was something really obvious, they would have been advised. Now, there are some paths for sure, but we definitely haven't taken the time yet, because right now we have other paths that are better. That don't, remember, damages means shovels in the ground. So it's not a possibility that we're looking forward to. So it doesn't make sense to spend your money at this point in time really exploring those options.
Isn't there valuation damage? Like if I have a home backing on the golf course and it's publicized it's going to be developed, you damaged my valuation of the home.
We don't have that yet. I
Mm.
mean, if you want to come to me with,
Yeah, it's happened.
It's happening because people who have been trying to sell their homes, as soon as they heard about this, are not getting the price. I want to talk about integrity. I just have to say this. For the developers that are here, some of the developers are the people who sold those houses to those people originally when they were built.
Right.
And they paid $100,000 more, I'm just guessing, to be on the golf course. Now the same developer is going to devalue that house, probably $300,000-$400,000 at today's prices. Devalue that house if they win this. You know, they are going to devalue those houses. So they've got money, extra money from that, and now they're going to get money because.
well, they're not going to get it for sure, but
Saying.
let's be clear, these are arguments we've made in the courts. I even took the court in their brochures where they said, we can charge premium prices for lots on the golf course. That's what they went into it thinking. And the Court of Appeal didn't refer to any of that. So we still believe there's an injustice and that those are legally relevant facts that a court needs to consider. But the 40% agreement is still your best fight. Then there's other scenarios that involve, that may not result in those shovels in the ground. So I take your point, and if we were to commission, but again, this would be a lot of money to be spent, and none of these things are cheap. So to commission an expert report to find out if this decrease in value, because again, it's not just, we need something a lot more serious than anecdotal evidence. So again, it would be a significant expense. You're welcome to write to Barbara, but I'm saying there's no, it's not a slam dunk obvious cause of action that we can turn our minds to it. But again, it's a choice that you as a community have to make. If you want us to start exploring it now, give Barbara the money in.
I think we want to go down that track.
The integrity thing, though, is still the 40% agreement at its heart, and that's part of why that we've pushed that to this point, and we're so happy that the city is continuing to push it. I don't think the other is complicated, and it's not our best path.
Okay. Hold on, Tal. There's somebody behind you that hasn't had a question yet, so I'd just like to maintain some order here if you don't mind. Before we go home. Lady behind Tal hasn't had a question yet?
No, he has not asked a question.
Yes, he did. Already earlier. Yeah.
Already had one time.
Hi, I'm Christine Rothschild, and I'm a realtor in the area. I also used to work for the developers back in 1989-90. So I was there when Canada Avenue wasn't even there yet, Compo wasn't there yet. And I was working out of trailers, and we had our models set up. And Compo showed us the dream of Canada and showed us just what the impact of what they were going to do and the 40% agreement was going to have on the lives of all the people in the area. So I sold properties to every one of these people with the understanding that if you were backing onto the golf course, you were going to be protected. They paid money. So we talk about integrity. What about fraud? To me, at this point, I can't tell you about Minto because they weren't there. But Ridgecraft, they were there. So in my opinion, it's fraudulent. They are back and doing what they're doing. This is not a question. But when Compo sold to Genstar and Genstar sold to ClubLinks, they had a duty with this. And unless there was something in there that said, we're gonna scrap the whole thing and go back to people. Again, in my opinion, this is where the integrity is. And how can anybody support Minto or Ridgecraft anywhere in this city when they are going to do this to the people who have lived here for a very long time, put down roots? Now, let's go to another comment. And that is about the value of the houses now. You bet your bottom dollar that your houses over the past 6 years have absolutely been affected by what has happened. It will continue to be. As a realtor, I am fielding calls all the time on properties that I have. Some of them might back onto green space, hallelujah. And some of them back onto the golf course. And you don't think that those people, if they're successful at selling, aren't selling for lower than they should be, simply because of what is happening. So it is imperative that we all continue to fight this fight together, because Lord knows what's going to happen down the line if 1,500 homes come into our beautiful community. The blasting, you tell me how that's not going to affect our dollar values just with that.
Thank you, Chris.
I do think we have to be careful when we throw words like fraud around. The 40% agreement was registered on title in all the properties. There was no deceit. Yeah, and that's, I think there's a difference in my mind from saying there's a lack of integrity to saying there's fraud. And part of it's because I'm a lawyer. Like I said, I need a cause of action. And the concern here is fraud has an element of deceit, and they registered the agreement on title. I think there's a complete lack of integrity. And what you're talking about, as I said, is those marketing materials that they filed. And that's where the Court of Appeal ignored the relevant. Is somebody turning? Okay, well, anyway, I'll say they ignored the critical factual matrix, and they ignored ClubLink's conduct. And we think that's a critically important aspect. And by ClubLink, they stand in the shoes of all the developers because they assumed those obligations. They also assume all the actions of ClubLink. So they're highly relevant. I just don't want it said that we're alleging.
And just always remember, so the 40% agreement is definitive, right? It's plan A, because it's definitive. If we win, this problem stops. I wish this would stop. If we succeed with the 40% agreement, the problem is resolved. Everything else also takes time, also takes money, perhaps less money, but it takes more time, right? And as was said earlier, for some of the envisionings, I mean, we all watch the law shows, we've got to suffer damages. On the matter of the property value issues, again, the coalition, I believe, is well placed to leverage that kind of investigation for the community, to go out and get assessors and do that kind of work. It's something we could pursue if that's what needs to be done at a certain point. But again, as of today, we're still on the legal path of protecting the 40% agreement. And so, as Alyssa has said multiple times, and I do not like to speak for the board without talking with the board, but I understand the thinking of the board. It does not seem appropriate from a financial protection perspective, and we are protecting the money you've given us, that we would go out opening 3 or 4 new doors of funding on a what-if basis. So I'm hearing you, and you know, we too share that sense, but we can only reasonably open so many doors at once. We can only reasonably open so many doors. Tao, thank you for your patience, and it could be the last question.
I just want to follow up on that. So, Alyssa, we have spoke about the misrepresentation in the past. There are multiple ways to interpret that agreement, and obviously, all the judges just interpreted the way that ClubLink wants, right? So that's to be the cause. I mean, we all write that agreement written by the developers, and then what's happening is we thought that we have protection, but now the judge look at a particular very, very narrow part of development and then saying, okay, that's the essence of the agreement. That's not true. I mean, I mean, there are something wrong here, very, very wrong with how it goes so far, right? And I'm now talking about if we risk a case of misrepresentation and we win, is it going to stop the development, right? And whether there's a guideline to apply for misrepresentation. Okay.
So just to clarify, we've never disagreed with the interpretation of the agreement that there was a path to development. As I said, I had shown a flow chart to show how unlikely it was that that would ever occur. And like I said, I think it's probably less than 1%, but it was there. So to the extent that the courts have found there was a path, we don't disagree with that interpretation. And because the agreements are on title, it's not a secret that that existed. Now, again, it doesn't preclude a different cause of action. But there are some, again, and maybe misrepresentation in the end is possible. But again, none of these are slam dunks. Otherwise, we would have suggested that to you. But we're open to going to look at it at a later time. But as Barbara has said, the 40% agreement right now, we don't think we need that. We think that right now, the best way to enforce the essence of that bargain is through the 40% agreement itself and by the Supreme Court of Canada. So we're open to pursuing that, but there's a reason Barbara has $50,000 left, because we're very surgical in how we approach things. The board is very clear in their instructions to us what they want us to do at all times. So, you know, I would love to do these legal explorations. I'm a law nerd at heart, but that's not how we work for clients. Clients tell us what they need, and we give them advice on strategy, and we're totally in agreement with the board's strategy to focus on this for now. It gets you your best result. The rest of it is interesting from an academic perspective at this point, but we're not there yet. Again, this decision to not give up on the 40% agreement, we stand behind it. It's what we hoped the city would do, and it would be our recommendation as well.
I mean, we know that.
I won't take long. Maurice Klein, I'm in Canada Lakes. From time to time, I see in Facebook these ads from Minto saying, "We build." And then so I, in the comments section, I always put a little paragraph saying, "Are you sure you want to buy a home from these people who are trying to destroy our community?" And that's worse than a drop in the ocean. It seems to me we've let Richcraft and Minto. We've given them full rein to ignore what we're doing, except on meetings like this. And it seems to me that, and I said this, I think, about 5.5 years ago, the equivalent of, why are we letting them off the hook? Why aren't we letting our community know what's taking place? So I, in Toronto, couldn't give a damn about what's going on, as long as it doesn't really affect his bottom line. But Richcraft and Minto have reputations to uphold in this community. So why aren't we going after them publicly and legally to let the people of Ottawa know that this is not an ideal situation? And people, before they buy a Minto house or a Richcraft house, wouldn't it be productive to let people know what's going on in our community? That's it. Thank you.
I'll be waking up with nightmares of microphones here tonight. Thank you for the comments. What can I tell you? We are a volunteer-based organization. The board has had many discussions at various points in the 6 years at various junctures. We've had members of the public tell us we should be picketing Minto, Richcraft, new home building. We should be out there doing this, that, and the other thing. And the board has seriously considered it. The board is a volunteer-based organization. We need volunteers, Mr. Kalani. So at the end of the day, if that's the kind of thing that the community wants to do, then come together and do that. But we've never had a wealth of volunteers say, well, this is what we want to do. You mentioned 2 words. One of them was legal. I've never heard, again, from the professional on my left that there is some legal argument to take with the signboards about new housing in and around Canada Lakes. And by the way, I'm very offended by them as well. I'm very offended that they actually have the audacity to draw beautiful homes with water and trees around them. And meanwhile, the new housing up on behind the beaver pond is sitting on rock and mud. So I share your frustration. And that's a way to go. But it never appeared to us to really be much more than maybe we feel better because we vented at the end of the afternoon. It's something we can think more about. In the context of a public campaign, maybe it's something we can think about. But again, we've got to be very careful. As a risk manager, a healthcare professional, manage risk. As a business person, I manage risk. I certainly would want to talk to this person next to us before we start going down those kind of paths. But I don't think it's lost on anyone. It is quite offensive. It is quite offensive. Yes.
Thanks. My name is Frank Kelly. I've been a resident of Canada Lakes for almost 27 years. Good evening. My kids have had junior memberships at the golf course, so familiar with the situation. Question is a really brief legal question. A lot of references, or there was a reference to the NCC. And my question is, are they potentially a partner that can join this petition? I guess my question's for Alyssa. The NCC, are they a partner that could potentially join this claim? Or are they just simply being held in reserve for an alternative at a future date?
I actually think, I don't know whether Jenna Sudds would want to comment on this. It is certainly NCC is involved. NCC has been involved from the get-go on this application, Frank, and they've opposed the application from the beginning because they are a downstream landowner. And as far as we can tell, they continue to do that. I certainly, Jen, over the years, is following that in her role. She has discussions with them. My understanding from the city is that They are constantly in discussions with the city on the land that they own and shared waters elsewhere in the city. At the end of the day, it is very important. It's very central, as are all the other downstream landowners, like the Canada North Tech Park. Because whatever happens in that watershed, it goes across those lands to the Ottawa River. So are they important on the issue? Yes, they are. When you're on a legal pathway, do they have a place to dance? Not really, not really. But in the city, within the city and within the city's planning structure and the discussions around a future ClubLink development application, because they still don't have one at the moment. It's not complete anyway. There's 192 clauses that need to be answered. So that could very well come into play, and the role for the NCC there. So we may have some good work for MP Sudds down the road, but for now, it's a monitoring situation. But I'm looking at her and she's nodding her head. As far as I know, the NCC remains in opposition to this. They have not moved. They feel the changes to the Kizell, particularly the temperature and some other issues, are just going to compromise that water stream. But yeah, in the back of our heads, and again, when you think about a public campaign, who else could be involved? Who could partner? Who else could we engage? But I don't see it as a legal issue. It's not been a legal issue at this point in time because it falls under it's all within the planning scope. So it's just the other stream of the issue, pardon the pun. Okay, so, okay, Tao, can I let these people go? Okay, so, and we'll stay back, okay? Thank you, everyone. I know it's a big commitment. We'll be back in touch with you. Before I let you go, we have a provincial election underway, so once again, we'll be doing our election e-news, and I've